You know, there's this powerful idea at the very heart of our legal system that the bond between a parent and their child is sacred. It's considered a fundamental right. So what happens when the state decides it has to step in and break that bond, supposedly for a child's own protection? That's the huge question at the center of the case we're diving into today. Okay, let's really dig into this quote. This isn't just an opinion from some judge. This is a direct statement from the U.S. Supreme Court. And that phrase, irreparable injury, is just so incredibly powerful. Think about what that means. It's like saying the damage is so deep that no amount of money, no apology, nothing can ever truly fix it. That's why the court uses language this strong. It sets the absolute highest stakes for these cases.
So legal experts actually have a name for this, a disrupted parent-child relationship, or DPCR for short. But the key thing to notice here is the fine print. It's an involuntary disruption that happens when there isn't clear-cut evidence of abuse or immediate danger. And that's the murky water where the state's duty to protect a child can really clash with a parent's fundamental rights.
And the reason this whole thing is taken so seriously is because it's baked right into the U.S. Constitution. The 14th Amendment protects our most basic liberties. And the Supreme Court has said time and time again that the right to raise your own kids is one of them. So when the state gets involved, it's not just a family issue, it becomes a constitutional showdown.
So that's the legal principle, but how does it actually hold up in a real-life, messy, human custody battle? Well, let's take a look at the case of a mother named Kelly O'Neill and her daughter Maura. It all kicks off when the North Carolina Department of Social Services, or DSS, gets involved.
And right away, you can see the sheer weight of the state's concerns. This wasn't just one little red flag for DSS. It was a whole laundry list. They're pointing to Kelly's mental health, alleged drug use, a past history with the department, and, get this, 14 police calls to the home in just 5 months. From the state's point of view, this looked like an emergency.
To back up their claims, the court ordered a psychological evaluation. And what that psychologist found was just incredibly damaging to the mother's case. The expert opinion that she was likely self-medicating added this professional, almost clinical layer to the state's argument, suggesting a pattern of behavior that could really impact her ability to be a parent.
And this is the exact moment when the whole situation just explodes. After being hospitalized for a mental health assessment, Kelly does a couple of things that DSS sees as a direct challenge. By tearing up a safety plan and refusing their drug screen, she basically forced a confrontation that led the court to do the one thing she feared most: remove her daughter Maura from her home. But, you know, every story has two sides. And from Kelly O'Neill's perspective, this wasn't about her being defiant. This was a battle against a system that she felt was setting her up to fail from the very beginning. This table right here, it pretty much sums up the entire case. It's the ultimate he said, she said. On one side, you have what Kelly says she did: weekly therapy, drug tests with her own doctor, online parenting classes. But on the other side, you have what the state could actually verify. And from their perspective, none of what she was doing met their specific requirements. This gap between what she said she was doing and what the state could prove became a canyon they just couldn't cross.
Now, the law says that DSS has to make reasonable efforts to help keep families together, and DSS pointed to things like a team meeting and a safety plan as proof they did. But Kelly's lawyers fired back, saying those were just administrative boxes to check. They argue that DSS totally failed in its core duty to give her real, actual support that could have helped her fix the problems.
The fight even spilled over into social media and the First Amendment. The court hit Kelly with his sweeping gag order, banning her from posting anything about the case online. She fought back hard, saying it was a violation of her freedom of speech and arguing that her Facebook posts had nothing to do with why her daughter was taken in the first place.
But as this legal battle dragged on, the communication from Kelly got more and more desperate and more volatile. And this was the turning point that would lead to the court's most drastic action yet. And it's also when we finally hear from her daughter.
I mean, just look at this text message. This was sent by Kelly to the DSS staff, and it was presented as key evidence. Now, for DSS in the court, this wasn't just seen as an emotional outburst. They saw it as a threat, a sign of dangerous instability, and it made them completely reevaluate the risk to the child.
And the court's response? It was swift and it was severe. Those messages led directly to an indefinite, total ban on any and all contact between Kelly and her daughter. No phone calls, no visits, nothing. The door was just slammed shut.
In the middle of all this chaos, the child's own legal advocate brought Maura's words to the court. And this quote, it's just devastating.
That feeling of being used as a therapist shows you the incredible emotional weight that was put on this kid. Her saying she was done with her mom, it just recentered the whole case on the very real and possibly irreparable damage being done to their relationship. The exact DCPR we were talking about earlier.
So you see how this one family's story opens up a much bigger, much more fundamental question. How do we, as a society, balance a parent's constitutional rights with the state's duty to protect a child?
And this is where the legal argument gets really fascinating. Kelly O'Neal's parental rights were never officially terminated by a judge, but that indefinite no-contact order, it effectively did the exact same thing. Lawyers have a term for this, a de facto termination. It means termination in fact, even if it's not a name. It's a way of getting the same result without going through the same high-stakes process.
And that is the core legal dilemma here. To formally, permanently terminate parental rights, the state has to meet a really high bar of proof, clear and convincing evidence of harm. But this no-contact order, it was issued based on a much lower, more subjective standard, what the judge felt was in the best interest of the child. So it raises this huge constitutional question about due process.
Now let's circle all the way back to where we started, that idea of an irreparable injury. If the state wrongly breaks that parent-child bond, how could you possibly put a price on that kind of damage? Well, believe it or not, some forensic experts have actually tried.
This is the figure some experts have come up with for the emotional suffering from a disrupted parent-child relationship. $650 per hour. It's a shocking number that really tries to make this deeply abstract emotional injury feel concrete, by translating lost time and pain into a cold, hard value.
Ultimately, this case leaves us with this incredibly difficult, almost impossible question. When the state steps in to protect the child, at what point do its actions cross the line and cause the very irreparable injury the Constitution is supposed to prevent? It's a razor-thin line that courts and families have to try and find every single day.